You know those days, some days where you just can't get something right, so I'm going to try and do this intro for the 5th time now. Okay, so good afternoon. It is 2 PM on Monday the 21st of June 2021. My name is Aaron Hunt. I'm a partner here at the law firm Stace Hammond, and I head up the immigration team here. As always, this video is not legal advice. It is just our commentary on immigration here in New Zealand. If you're looking for legal advice, then down in the description below you'll see our email address. Send us an email and we will respond to you as soon as we can. Today's just going to be a quick update. We are working on a larger piece that is actually hopefully get finished this week, and now that my workload's a little bit less crazy than it has been recently. We'll come back with that when we can. We do want to just cover a quick few topics today just to update you on what's happened in the past week or so. First is the new exception they released last week, the new border exception, which will likely be of use to probably none of you. Next will be the change to living together requirements under the operational manual, which they sort of slipped in there without anybody really noticing. Then we'll have an update on our discussions in the last video on character waivers around nurses. And finally, we'll have a quick comment as to the skilled migrant queue and a response we received from immigration. Now, if you find this video of use, please do like it and click subscribe, hit that bell icon to be notified about new videos. Clicking like and that does really help us get the word out there, so please do that. Our next video will be something more substantial and also be coming around the same point we hit 5,000 subscribers. So thank you to all of you who have subscribed. It really does make me feel like, you know, I'm doing some sort of good with these videos. Okay, so we'll start first with this new exception that was announced on Thursday, and this came through as an announcement through just the change to the operational manual. For those who don't know, the operational manual is the rule book for immigration and what Immigration New Zealand needs to follow. So when you see us respond to questions, you often see us refer to the operational manual, as it's usually the best place to get an answer. Now what's weird is that this change to the operational manual wasn't otherwise announced. There was no press release, which we'd typically see. Actually, I spoke to an MP who has a strong interest in immigration. I'm sure a lot of you know who they're talking about. And they weren't aware of it either. It just sort of came out of nowhere, this strange border exception that no one knew was coming. It just sort of appeared. Now it isn't yet showing on the online operational manual. It hasn't been updated yet to show this. It usually takes a week to do. But now we do know that the changes came into effect on the 14th of June. It's when they actually did come into effect, even though you're not aware of what the changes are. We got notified on this June 17th by an email from immigration. We call it an amendment circular that sort of updates us on changes to the operational manual. We got down the 17th, changes on the 14th. Nothing officially released as a press release. Now it all falls under H7 in the operational manual. Now the H section is all around border exceptions, about how people can get into the country with the border closed, with the exception of border exceptions for Australians, which they hid away in H7.5. We don't know why. Why make it easy for people to find these border exceptions? But generally, apart from Australians, everything else falls under the H section when it comes to border exceptions. Generally, there's always exceptions to the exceptions. H1 is general objectives. It's very short. H2 handles a couple of lines about diplomatic staff and their dependents. H3 is a single line that domestic staff of the diplomatic staff don't get exceptions. H3 is just literally one line. H4 handles those who can apply under H2, which is again a rather small section. H5 is the main exception section for most people. It's substantially larger, it is massive in comparison to the other sections, and it's more detailed than all the others. It covers the critical health workers, other critical workers, humanitarians, just about every other category not related to diplomatic staff. They all sort of fall under H5, and you'll hear us referring to H7.5 a lot, because that is where a lot of these exceptions lie. H6 came through later in the year, and that covers those partners from visa waiver countries. So it's sort of extended rights that had under H5 into H6, which if you came from a visa waiver country, you had different allowances there for you. We still haven't found the section that relates to entertainers or nannies of celebrities. That's still hiding away somewhere in the operational manual. We're still looking. Now, H7 is the new one that appeared out of nowhere. Now, after talking to the MP, we're sort of coming to the conclusion that we're going to call this the Olympic exception. It's not available online yet, so we'll cut and paste a few bits into the description below so you can see what the wording says in parts of it and get an idea as to why it's there. Now, under H7.1, the objective is to facilitate the re-entry to New Zealand of temporary visa holders who travel for reasons of national significance with COVID-19 border restrictions are in place. This, of course, could cover a lot of different things, as national significance can go fairly far. However, H7.10 restricts the exception to applications made before 13th of August 2021. Now, the Olympics end on 8th of August 2021, so it gives a few weeks in between the Olympics ending and this, having to apply for this border exception. But we also remember that the Paralympics, of course, come after the General Olympics. And they end on 5th of September, which would sort of cover, if you went to that, you could apply for the border exception before the 31st of August and then come home after the Paralympics are finished. So the short period of this allowance just seems to give us this idea that it's been brought in for some reason, and we think that that reason just has to be the Olympics. We can't think of anything else that would have this exception come in to sort of just fit this area. Now, there is a requirement for the person to have been approved by the Ministry of Health, or that it meets the intention of the Ministry of Health criteria for early access, which we haven't really been provided with, except that under H7.15.5, it does state that this can be proved by an email from the Ministry of Health that they have early access to vaccination, something which has been given to those who are going to the Olympics. So I think that's basically an email from the Ministry of Health saying, yes, you have early access to vaccination for a reason, Olympics, and that is enough to help you get this border exception. Now, under H7.15.10, I say I would link to H7, but it's not online yet. We'll link to the H section, so you can sort of see that section, and it might appear at some point soon. Now, under H7.15.10, a variation may also be granted under this condition if they were already vaccinated, had already left New Zealand, can't be vaccinated, or cannot have received both doses before they travel out of New Zealand. Now, INZ will make a decision in those circumstances based on other information provided, including lists provided by relevant government organisations. Now, it says that those are listed on the INZ website, but of course, as this change isn't listed yet, we don't know where those things are listed. The website could be better formatted and more logical to find things. Partners and children can't be included in that. It is just the applicants themselves for what will intend to be short trips to Japan. Doesn't say the word Japan, but that's just our presumption. So this is why we call it the Olympics exception, because it seems to be aimed at that group of travellers going to an event of national significance, being the Olympics. There's also been a change, just as a side note, to H5.25.15c, which has been updated. Now, typically, you have this exception which allows workers of certain types to be allowed to come into the country or apply for a border exception, a certain number of them. So we had veterinarians, one of the first ones, at 200 of those. Recently we've had shearers, 50 of those I think it was, who can get a border exception. Now typically that was required to have Cabinet, which is basically the central part of government, approving those changes. Now it's been changed so the Minister himself can make those changes. It's a small change, but an interesting one to note that the Minister now has that power, but before it belonged to Cabinet. Another small change is in Y330, which has been updated. Now Y330 covers those who are considered to have been granted an entry permission during the border closures. It's now been clarified in Y330B1 that someone who has had their visa varied to allow entry maintains that right to enter. So there's been a question we've been asked a few times, is that if I get a border exception, so say if you have a visa as a nurse and you leave the country, you apply for that border exception to come into the country, and they give you a variation to your visa. You already have the work visa, so they vary it to allow entry. This seems to clarify that variation to your visa allows multiple entry. Means that you can come and go from the country. Now, I'd want to sort of check this with immigration themselves to make sure, but that seems to be what this change in Y330BI seems to make. The one final change here, and this is one that sort of just, again, snuck in there, this was in the changes from the 17th of June, is that visas granted to other critical workers where previously, they were previously 6 months, although those who were earning at least twice the median wage could get 12-month visas. It's now been updated so that to gain more than 6 months, you need to show you need to be in the country for more than 6 months, no matter how much you earn. So even if you earn twice the median salary, and you can show there's a critical purpose of being in the country, you need to show that you need to be in the country for more than 6 months if you want to get more than a 6-month visa. So INZ seems to have been getting skilled workers a little bit harder than it was the week before, when companies are already struggling to try and find critical workers and staff they desperately need. Immigration New Zealand has made it a little bit harder to get them in here for more than 6 months. Okay, next one is living together. I just wanted to comment on this. This was another change that was made to the operational manual over a month ago that people didn't really notice. I must admit it actually did slip our view for a short period just because of the timing it came out, and we'll come to that in a moment. Now, as we covered many times previously, the description for genuine and stable and living together have been in E4 of the manual for years, and they are two different things. E4.5.25 covers genuine and stable. E4.5.30 covers living together. They are then brought together under E4.5.35. So a couple can be genuine and stable without having lived together. And this has been that way for years. It's been established for years. We've had decisions from immigration saying, we know they're genuine and stable, they haven't lived together, and they can be not have to have both of them. Now, sometime in mid-November 2020, we started seeing INZ taking a stance that genuine and stable requires having lived together. We raised this with the head of border entry at the time, and he said that Immigration New Zealand's take was that a couple cannot know they are genuine and stable without having lived together previously, as living together raises other situations that a couple may not have otherwise been aware of. This is a view that we have always disagreed with. And we know that many Hindi, Christian and Muslim clients will also disagree with that approach. We've seen couples who have spent years together, dating, spending almost all their time together, communicating frequently, knowing each other so well, but they have never shared a bed, never slept with each other. And we believe that that does not mean they are any less genuine and stable than a couple that have. A decade of dating and being together compared to a month of living together for a new couple, we can see which one is going to be more genuine and stable, and that is the one with a decade of relationship. But that is not the view Immigration New Zealand are now taking, despite that being different to what it's always been for so many years. Now, we raised this because up to this point there was no requirement for genuine and stable to have a factor of living together. They have been different things. They can both be required for applications, and they often are partnership visas, but they're not the same thing. However, there's now been an update to the operational manual. H7.5 20F states, for the avoidance of doubt and the purposes of A, C and E above, a person will only be considered to have met the requirements of partnership if they have also lived together. Now, which kind of does try to tie in this whole sort of living together, being genuine and stable, but even then it doesn't really state it. It just seems to be trying to fix a situation where they've been caught out on. Now, this change appears to have been made on the 3rd of April 2021. The change itself was notified to everybody on the 7th of May 2021 with an effective date of 10th of May 2021. And you can see the changes in the Amendment Circular 2021-14, which we'll link to in the description below. So now, remember, this was the week that people were flying to Wellington on that Thursday to appeal to the Minister to be in Parliament for the reading of the petitions and ask that they reunite families, separated families, that the Minister have a heart and reunite them. This is the week that this came through. So a few days before we were all down there in Wellington, have you seen the video that I put out there, and I'll link to it below. They put this change through, making it more difficult, sort of cementing in place this change, which so many of us have said, well, that's not what the rules state. Now it does. They've made this change in that week, which is, despite years of relationships or marriage via customary practices, Immigration New Zealand now require them to have lived together before they can be judged as being stable, despite any other evidence. So that is now the rules. Now, we're going to look again at character waivers in regards to the nurses. We wanted to quick update on the situation. We covered it in the past video. One of our subscribers was very kind to send through a character waiver decision for another nurse to give us another point of view. Now, in our video, we mentioned that it appeared to be that those who had been called and denied having assistance with the application were being declined. but those who had been called and sort of admitted that they had had assistance, obviously not knowing that there was, you weren't allowed to have that a licensed advisor helping you out. We thought they had actually gone through because we'd seen no people being declined in that situation. However, in the example provided, the applicant, it was admitted by the immigration officer that the applicant said that they weren't aware that an advisor needed to be licensed, and there's no reason why the immigration officer believed otherwise. They seem to have accepted that the applicant wasn't aware of that requirement. However, the immigration officer decided that as the applicant had travelled overseas before to a place that wasn't New Zealand, another country that was not even close to New Zealand, that because they travelled before, they should have been aware of New Zealand's rules, or they should have spent more time looking into New Zealand rules to be aware that they weren't allowed to use an unlicensed advisor. And that it's their fault for not looking this up and just for trusting somebody who said that they could help them out. And for that reason, and this is the crazy bit, for that reason, because they hadn't done that investigation, they were therefore not bona fide and were not coming to New Zealand for the reason that they indicated, being to do a CAP course and to be a nurse. Now this was someone who is a nurse already, trained overseas and spent years being a nurse. That the fact that they didn't research into New Zealand enough to know the process, that they've been deemed to not be genuine in their intent. And the fact that they had travelled to another country previously meant that they were not being genuine in their intent. I just can't get my mind around this thinking. It's beyond us. So where we would believe previously that those who admitted in the phone calls were being granted the visas, we were incorrect. At least one person here in that situation was declined, and we can't see a logical reason why. Now we've put an Official Information Act request in to find out how many of these CAP applicants were declined. We've also put in a request to see how many declines this actual immigration officer who did this particular waiver has declined, and do a comparison on percentages with that person and other officers to see whether there was a high percentage with that person's declines, because we're having difficulty understanding the basis for the decline there, or the mindset behind it. And as we mentioned in the video last week, once you have that decline, you have a character issue, you can no longer apply for an expression of interest, that you are blocked from doing so. You'll get declined, or when you apply you'll get declined at the ITA because you have a character issue. It means that you have very few ways to actually contest this. So we're going to try and hopefully do it for you, try and find that if there has been an issue in how these have been handled, by looking at any more that we can get through. So if you do have other, if you did apply for as a nurse and you were declined because of this whole issue with perhaps you using an advisor or having a friend help you out, and you got that phone call, if you have a copy of your character waiver decision, then please pass it through to us. We'll keep it confidential, of course, but it will help us to make our arguments. We'll be able to see whether there was other officers involved, whether there was some sort of common view of it, whether things were handled correctly or not. If you were granted a visa, had the same situation but you got granted a visa, please would ask for the same thing. We want to see as to how they looked at yours compared to the other ones, and see whether there was a difference somewhere in how it was handled. Because as far as we can see, we just can't make this logical connection between wasn't aware they couldn't use an advisor to basically coming to New Zealand for a purpose other than to be a nurse. It just doesn't make sense to us. Finally, I want to just quickly touch again on the skilled migrant queue. Now, there's been nothing more from the Minister apart from the usual talks of reviewing it and keeping New Zealand safe, so I'm not going to announce to you any changes here because there have been no changes, been no movement on this whatsoever. We do keep seeing media reports of those people who are trapped by the situation, who have been asked to come to New Zealand, sort of enticed to come here with this whole promise of come here, work, become a resident, have your futures here. And then once they get here, they're denied that chance to be a resident. The Minister talks again instead about training New Zealanders and about keeping the borders safe from COVID-19. But for one situation, we'll link to the article below, that shouldn't really apply to a doctor who is already in New Zealand, working to keep New Zealanders healthy, but is in limbo due to that residence, that stop on residence. We don't see how delaying the SMC draws any further for those who are in New Zealand means more New Zealanders will be trained as doctors. It doesn't work that way. This takes like a decade to train. It won't suddenly be, oh wow, We can't have people on, we'll train people up to be doctors. That's not how it works. And we're also not sure about how it's keeping New Zealand safe by people who are already on shore. This doctor's in the country already. She's been here for years, but yet she cannot apply for residence. Now, we put in an OIA request about this a couple of weeks ago to sort of get information or some sort of response from the government as to why there is this delay. Strictly speaking, it wasn't an OIA request that we should have been doing, but there was no other way to do it. We thought we'd give it a shot. Now, we received the response, and it included these words. Now, from 1 April 2020, the selection of expression of interest for residents under the parent category and skilled migrant category were deferred until later notice. The deferral is a temporary measure that allows INZ to focus on processing applications from people who are in New Zealand or those eligible to travel here while border restrictions are in place. The government has not yet made any decision on when this will reopen. INZ will continue to reassess when EOI selections can take place as the COVID-19 situation develops. Now, the words there, of course, is from people who are in New Zealand. Now, this, of course, ignores skilled migrants who are in New Zealand already. Now, the response is, yeah, we're going to keep it open for those who are on shore. Great, do it. We believe that the government should at least be giving an indication or a start date or something on when the draws will start, even if it's just for those who are in New Zealand, which the vast majority of SMC applicants are. They are on shore. If you want to keep the border secure, keep the COVID-19 as annoying as it is for so many people out there, using that as an excuse to stop those who are already in New Zealand from applying is just dumb. And well, that is it for today. We're still working on a larger video, which we'll hopefully have out to you later this week or early next week, depending on workload. Until then, kia kaha, stay safe.